Ohio's smoke-free workplace law upheld. Enforcement of law against Columbus Tavern is not unconstitutional taking of property. Winslow versus Bartek Incorporated, case number 2011-0019, 10th District Court of Appeals, Franklin County.
This is strictly a regulation of some property, but not others. And that's what really makes this a property rights issue. This is not a regulation of conduct. So, for example, the ban does not prohibit smoking. It doesn't say that you cannot smoke anywhere. It says that you cannot smoke at Zeno's and you cannot smoke at a number of other places. And in fact, it exempts, it allows for smoking at places where there's an economic hardship, such as retail tobacco stores, but doesn't allow for smoking at other places where there could be a similar economic hardship. And it allows smoking in places where there could be children, even though a place like Zeno's does not have children.
What does a bar owner do when a patron chooses to smoke and the owner says you can't do that?
Your Honor, the bar owner does what the statute requires, which is 1, post no smoking signs, 2, pull anything that's a traditional ashtray from the establishment, and 3, ask people to stop smoking or inform them of the ban. At that point, the statute isn't clear on what they have to do. Now, the health department added to the requirements or the liabilities on proprietor, which I think is also beyond the scope of the statute, saying the bar owner must take reasonable steps. But they've never clarified what reasonable steps mean. Private property rights are fundamental rights. And the Ohio Constitution does allow for greater protection of private property rights than the federal Constitution. It's not just the right to own property that's a fundamental right, but it's also the right to use and enjoy property. And that's important.
Nearly every regulation under the police power is going to interfere with the enjoyment of liberty or property. Thus, when the court articulated this test, it recognized that it was using a deferential standard in spite of the fact that almost every police power regulation is going to somehow implicate private property rights. And Zeno's attempt here to import the language from Norwood, referring to fundamental property rights in the context of an outright taking, using the state's eminent domain power to physically seize and take someone's private property, does not just transfer into the context of the standard for evaluating a police power regulation on its face. Saying that property rights are fundamental for the purpose of eminent domain or taking analysis, and indeed saying that property rights are fundamental in Ohio is not so novel. Ohio has always had great respect for property rights.
But the idea here is what government can do to an establishment that is pre-existing, as counsel is pointing out, where people can drink and smoke if they're over 21. The government coming in saying, now you are not going to be able to do that.
The statute itself sets a higher threshold for patron liability than proprietor liability. A patron is only liable for a violation if they have been warned by the proprietor to stop smoking.
And is a sign posted a warning?
A sign posted is not a warning for purposes of that. That is a separate requirement under the Act.
On May 23, 2012, the Supreme Court of Ohio affirmed a ruling by the 10th District Court of Appeals that upheld the Ohio Smoke-Free Workplace Act as constitutional. The court's 7-0 decision, authored by Justice Judith Ann Lanziger, rejected claims by the owner of Zeno's Victorian Village that fines assessed against his establishment for violating the statewide ban on smoking in places of employment exceeded the state's legitimate police powers or were an unconstitutional government taking of private property.